development of substantive norms of international human rights and international criminal law has not been matched by the development of mechanism and procedure for their enforcement. The primary methods of judicial enforcement envisaged by international law are the domestic courts of the state where the human rights violation or international crime occurred, and the courts of the state responsible for that violation. To this end, international law imposes obligation on states to prosecute those who have committed international crimes within their territory. Likewise, human rights law includes a right to a remedy or to repression provided by the states that has violated the substantive human rights. However, this method of enforcement of human rights and international criminal law often fail. Domestic law may not incorporate the relevant international human rights norm. International crimes are often committed by the state's agents as part of state policy. And so governments do not routinely prosecute their own officials engaged in such action, to us has happened in Latin America. Change of government may bring a change of policy and prosecution for past official conduct.
Diplomatic immunities and protection can be referred back to diplomatic law. On that diplomatic law, we narrow it down again. Specifically, it's about the grant of immunity from local jurisdiction. In this respect, international law recognizes two types of immunity from jurisdiction in relation to officials of the states. The first type of immunity is immunity ratione personae, which is immunities enjoyed by the virtue of their office. It is important to their protection and facilitation. For example, when a diplomat gets arrested, whatever the reason will be interfering with his ability to perform his official function, or even freedom from the detention. Take note, ratione personae will only attach the particular office of the state, rather to benefit the official holder individually. Head of state, head of government, and foreign affairs minister enjoy immunity from ratione personae from foreign criminal prosecution, which is act privately or act performed officially before or during the term of office. The second types of immunities is immunity ratione materiae. In contrast to immunity ratione personae, it attaches to the official acts of the state official. Ratione materiae is immunity that attaches to the person of an office holder. The foreign official are personally embodies the state. The act of foreign official is attributed to the state, as well as the state itself is immune from jurisdiction. The representative itself should be also immune. Immunity ratione materiae extend to ex iure imperii and ex iure gestionis, provided they were not performed in a private capacity, rather to official acts. As we know that diplomatic law is not fully codified and certain categories of those engaged in the conduct of IR. Therefore, enjoy immunity only by virtue of international customary law, and by distinguishing those two immunities, we can also reconcile the issue of immunity of foreign state officials from criminal proceeding, especially when they are prosecuted abroad, on the basis of duty to prosecute such grave crimes, such as crime of torture. As example, the first case is Pinochet case, which is involving former Chile head of state, General Augusto Pinochet, indicted for human rights violation. It marked the first time judges had applied the principle of universal jurisdiction, declaring themselves competent to judge crimes committed in a country by former head of states, despite the existence of local amnesty laws. The Pinochet case denied the immunity of the head of state. The Britain law lords held that General Pinochet could be prosecuted in Britain or extradited to stand trial under British Act of Parliament, which gave effect to British obligation under international treaties. The immunity performed in the Pinochet case was conducted under the principle of ratione maturiae, whereby the immunity survives after the end of the official functions. However, the case is still debated whether the case reflects the current status of customary international law. In contrast, if you know Iran-Warren case, which involved Belgium versus Congo, sued Congo's foreign minister, Yerodia, that was accused for inciting racial hatred on his speech, incited the population to attack Tutsi residents in Rwanda. Iran-Warren case affirms the immunity, so it's different from the Pinochet case, which is denied the immunity. The immunity performed in the Iran-Warren case was conducted under the principle of ratione personae, which the foreign minister was immune from criminal prosecution before and during the term of office.
After talking about those diplomatic protection, including the issue of immunity of foreign state officials from criminal proceeding, now I'm gonna tell you such of diplomatic immunities and privilege enjoyed by state representative. Diplomatic immunities. Diplomatic relation and along with its immunities are codified specifically in the 1961 Vienna Convention on Diplomatic Relations, also called VCDR. It is among the most widely ratified of all international conventions, and its aspects, which were originally progressive development of the law, now reflect the customary international law. There are 53 articles in Vienna Convention Diplomatic Relations. To take note that all immunities and privileges are given to state Vienna Convention Diplomatic Relations. To take note that all immunities and privileges are given to state representatives with the purpose of not to benefit individual but to ensure the efficient performance of the function of diplomatic mission as representing states, which is stipulated on Vienna Convention Diplomatic Relations. Preamble Alinea 4. The first one is property. Under Article 22 of Vienna Convention, the premises of the mission are inviolable, and together with their furniture and other property thereon and the means of transport are immune from search, requisition, attachment, or execution. The second one, the immunity in terms of personnel. The person of a diplomatic agent is inviolable under Article 29 of Vienna Convention, and he may not be detained or arrested. This principle is the most fundamental rule of diplomatic law and is the oldest established rule of diplomatic law. Remember, the aim of the immunity personnel must be secure first. The most familiar example of the breach of the obligation to protect diplomat was the holding of US diplomat as hostage in Iran in 1979 until 1980, where the international court held that the inaction of the Iranian government faced with the detention of US diplomatic and consular staff over an extended period constitute a clear and serious violation of Article 29.
Okay, that's all from our groups. I would like to apologize if there are any mistakes in giving explanation and the lack of information if there from us.